Hello, everyone. Welcome back to the Colombo Hurd YouTube page. My name is Mandy Nease. I'm an attorney here with the firm. And today, my special guest is my colleague, Roshn Vazhel, who's here to talk to us about the RFE trends and some strategies for responding to RFEs if you've received one. Roshn, welcome. Thank you for being with me today. How are you?
Great. How are you doing today?
I'm good, thank you. I wanted to talk to you about the recent RFE trends because I know we've seen an increase in RFEs on the NIW product. So let's get into it. Tell me about those changes to the RFE trends. And then in a little bit, let's move on to talking about what you and your team are doing to respond to those RFEs.
Of course. So the first thing to really start with is that self-petition immigration categories, which includes NIW, continue to face heightened RFE rates. This is in combination with the recent memo just clarifying that NIW is actually the employment-based immigration petition, the solo one, which is at officers' discretion. So officers do issue RFEs based on their discretion, their analysis of the case. And this is coming out in RFEs that are being issued recently. A lot of these trends are related to the January 15th policy manual update. While the update did happen quite a while ago, it's taken some officers to really dig into it and start adjudicating based on it. So we're seeing a lot of RFEs based around that, based on their interpretation of that. So the first trend that we're noticing is a heightened focus on national importance. The policy manual update did have some specific information about how national importance should be adjudicated going forward. This has been beneficial to some cases, but in some cases, it's caused officers to issue challenges. There's been an increased amount of focus on broader implications of the proposed endeavor, with a corresponding focus on unique methodologies as well as unique techniques and solutions related to that as a way to prove national importance and broader implications. So there's a focus also on economic impact, quantifiable outcomes for the proposed endeavor, as well as more detailed documentation of how that person's proposed endeavor is different than what exists in the United States or represents an improvement on something that exists in the United States when it comes to the methods or solutions that the proposed endeavor has. Another trend we're seeing is a decrease in the quality of requests for evidence.
Really?
Yeah. So in recent requests for evidence, it's been increasing over the months. We're getting not just increased challenges to things like education credentials, where officers are challenging every single piece of educational evidence, either by actually reviewing it or just challenging it wholesale, even when things are properly documented. But also including non-EB-2 NIW standards. We're seeing an uptick in heightened standards like actually asking outright for original contributions of major significance. This continues to be the minority of officers, but there is a subset of officers that are increasing the standards of EB-2 NIW past what actually is applicable to EB-2 NIW. Of course, this is something we can address when doing an RFE response, but it is troubling and speaks to a lack of training and care taken on the USCIS's part.
So they're actually bringing in those EB-1 criteria into the EB-2 analysis and denials?
Requests for evidence and denials. Sometimes they will use language that isn't exactly on point with EB-1A, such as requesting for impetuous of progress or substantial positive discourse as if that is a full requirement, or having been at the top of the field. Sometimes they will just straight up say original contributions of major significance without really understanding that that's not really what EB-2 NIW is about, and that is not related to prong 2.
So interesting.
Yeah. The last thing is just nonsensical requests for evidence that just ignore evidence or just have factual errors, basic mistakes such as just confusing people between people. And then also notices that just kind of don't contemplate either the initial filing or the RFE response at all, showing that they're not really examining the evidence much.
Right. So just kind of a disconnect between what's actually in the petition and what they're writing these RFEs about.
Yeah, and it does seem kind of like a lack of training in what's going on, because we are seeing that some of these RFEs do come from new officers that we haven't experienced before.
And certainly, I mean, I can tell you from my prior experience with the turnover that the federal workforce in general has experienced, and with a lot of the senior people leaving USCIS under the Trump administration due to the offers of early retirement and early resignation. I mean, I can see that training could be an issue, that those senior people who are used to upholding the standards of the product just aren't there anymore. And they're not there to do the mentoring. They're not there to do the file reviews and to help the newer officers really learn how to do it well. So, I mean, that totally tracks with my experience as a prior officer. I can tell you that. Okay, so let's talk about how you and your team are addressing some of these new challenges, if you don't mind.
Of course. So the important thing to note is that this is not just something that we're seeing. Everybody's seeing this across the entire field. But because we're a very experienced firm, a very adaptable firm, we're changing our strategies and continuing to succeed by changing how we operate and how we answer requests for evidence, as well as how we file cases. So I'll go into some of the strategies that we've been doing both for the initial filing of cases and if an RFE is to be received, how we address them. So the first thing that we do for initial filing, and it's very important, is that we should always try and include all relevant documents in the initial filing. Some officers are now a little strict about nothing past the data filing, even if it concerns things before the data filing. So having it already in the petition puts it on the record, and we can utilize it if an RFE is going to be received. And an important message is don't be humble about it. Don't think that, I need to gate my evidence to make sure I'm not providing things that I don't think are important to the attorney. Just provide everything. If you're working with an experienced attorney, they'll be able to review everything, tell you what works, what doesn't. Don't worry about sorting through the evidence first before you get to the attorney. There are things that are usable and are useful that you may not have thought were actually usable in your case. Just give us everything that you have.
I agree 100% with that. Some people they're so used to being humble in how they speak about their career accomplishments that it's really hard sometimes to get clients to switch gears on that and to really portray and really provide all the evidence of their professional accomplishments, which they do exist. But again, people are so used to being self-deprecating about it and not trying to self-promote that it can be tough to get people to, shift gears into let's put it all out on the table and really shine.
Yeah, of course. Yeah, that is 100% true. And it's increasingly important because it's not really the time to be humble. You may have felt like, okay, the attorney doesn't want to see this. I have other things. You don't really necessarily know that because you're the expert in your field, of course, but the attorney is going to be the expert in how do we frame things to the USCIS and what is the USCIS like. There's always a way to use a lot of different types of evidence that sometimes petitioners don't really see. The next two things that I think that would be good to discuss for how to improve initial filing packages to try and avoid these problems is also being very detailed in your statements, your personal statements, your plans, and how you're going to accomplish your proposed endeavor and what you'll be doing. This is particularly important because officers are looking for broader implications and what's unique about your endeavor. And also corroborating independent objective evidence that goes hand in hand with providing everything that you might have. Officers are becoming increasingly focused on having evidence that supports the letters on the record. If you have things that have happened, like in the letters, just provide any evidence you have that's related to it. You may think it's weak, But let your attorney make that determination to see if that is usable evidence that backs up the letter. It could be stronger than you might realize. Another thing, another thing that we would like to basically highlight is that you should align with the USCIS policy manual as much as you can. Of course, it could change, trends do change, but there's a focus on quantifiable outcomes, strong economic benefits, and objective evidence, as well as documenting US interest in your work. And this is another thing where you may think that something is too weak to be usable, but your attorney can guide you. For instance, you may think, oh, nobody in the US is interested in my work currently, but you may have people that you might know in the US or somebody you do know knows that could show interest in your work. And this is important to do before filing the petition. And this also carries over to recommendation letters. The pool of possible independent recommenders might be bigger than you think. These are things to talk about with your attorney because officers do really like independent letters, preferably from US experts. But sometimes petitioners get a little confused as to what is independent or dependent. And your attorney will be able to guide you through that and help you vet potential candidates for these letters.
And in terms of those economic impacts, do you kind of recommend that people think about a business plan or something along those lines? How do you help people establish those impacts?
Yeah, I would say business plans are decently important. They're not necessary. The only requirement is a model plan. So you can just do a model plan, especially if you're just going to be like, for instance, independent with a few employees, but you're not really running a full-scale business. A model plan is still fine. But if you do intend on like making a large-scale business, hiring many employees, then a business plan might be more appropriate. And I would follow the guidance of your attorney in that case, just to figure out like, do I need a business plan? Is it needed in my particular case? And what benefits might it give you? And another thing is that that's what independent experts are also good at. They're good at independently conveying economic impact and field-wide impact. Dependent recommenders can definitely do the same, but it does it does require less corroborating evidence if it's an independent expert, because their opinion will be more objective.
Got it. Thank you so much for that.
Yeah.
What other strategies do you want to share with our audience before we wrap up today?
Yeah, so I'm going to move on to how we address RFEs that we get and the strategies that we can take. Again, I'd like to echo something you said. It is likely the USCIS, not you. Officers that are new or difficult either don't really take the time to review petitions or don't really understand the NIW framework. So don't be discouraged if you get an RFE. You and your attorney may have done everything right. You have a solid case, but an RFE might still be issued that doesn't really contemplate the evidence or really understand the evidence. So when an RFE is received, a good strategy that we should take always is analyze each request. Don't make the assumption that the USCIS officer is actually correct in issuing the RFE. You want to view it as objectively as possible, along with the materials you have available, like the matter of Janissar, as well as the policy manual. This is definitely done easier from the attorney side. We're used to it. We have a wealth of cases we've handled and we're very familiar with the EB-2 NIW framework. You also want to organize RFE responses very clearly. And we are taking a strategy to always rebut officers where they are incorrect, because failure to do so can lessen the chances of approval. Officers will typically not concede a point unless they're corrected on it. You're basically, when you're not calling it out, just letting them think that they're right. And if they think that they're right, they'll just continue on with it because they haven't been, it hasn't been explained to them otherwise that they could be incorrect in what they're stating. Yep. Another thing is over document. We always want to include as much evidence as we can that is positive and strengthens your case. Of course, there is evidence on RFE that is not relevant to the officer's request. We don't want to go out of what the officer actually wants too much. But it's important to provide corroborating evidence. Let's say you filed a while ago, you had some evidence you didn't provide to your attorney at the time. Don't think that it's off the table. As long as the officer seems open to it, we can still submit it as long as it's before the time of filing. For instance, you have letters that discuss an important deal you made, for instance. The officer wanted some objective evidence. If you have the contracts, agreements, communications around that deal that outline your contributions and how major they were, that would be good evidence to submit. Another thing is always to account for USCIS trends and officer disposition. This is more easily said from the attorney side. To analyze what this officer's record is, what they've said before, what they seem to want, and try and figure out what the trend, what the wording in the RFE really means. What does the officer really want to see? And a lot of the time, it does boil down to focusing on very measurable benefits to the United States. It doesn't mean you only need to do economic impact. It doesn't mean you only need to make something entirely unique. You can also have strong impacts on public safety, on health. These are the broad implications that an officer wants to see. They want to see scope-wise, how are you benefiting more than your employer or your clients? They want to see how you're benefiting the United States as a whole. And we bring that out in RFE responses through the different types of evidence that we include.
Those sound like really effective strategies. Are you seeing approvals still, or what's happening after we get an RFE?
Yeah, we are still seeing approvals. It's a little more difficult, of course, with the way that officers are issuing RFEs right now and the particular officers that are issuing RFEs, but we are still seeing a constant stream of approvals. And the current environment overall is making things tougher for not just petitioners, but also legal practitioners and immigration. But it makes having experienced counsel really important. And because we have such a wealth of knowledge and we track officers, we are able to determine more clearly what an officer might want, which is still leading us to a great deal of success. Of course, it is more difficult than it was previously, but the way that we're going about it and how adaptable we are is leading us on the right path to dealing with what the USCIS is giving to us right now.
Yeah, it's such a tough job that you and your team have. I mean, it's tough on the success side, but it's also, it can be really challenging because clients are already a little discouraged. And again, I want everyone who's watching this to know that if you've received an RFE, it's not a reflection of your credentials. It's not a reflection of your counsel. This is where things are at with this agency right now. And your team has a tough job, but it sounds like you have some really strong and effective strategies for getting our clients from RFE, from that challenge stage into the success stage. And so I'm just so happy to hear that. And I'm so proud of the work that you all do. It's a rough spot to be in this process, but it's such an important process too.
Yeah, and we're handling the challenges that come our way. We're pretty used to it, and adaptability is key, not just for us in RFE, but for any legal firm to how, and especially in immigration, working with EB-2 NIWs, we're all adapting on all sides of the firm to make sure that we're able to give best chances for our clients for approval. And an important thing is that these changes are stemming from policy issues or from staffing issues, increased petition volumes. These are all things that are likely to be temporary. These are problems that can certainly be solved. So as we see things progress over the year, we hope to see the quality of the RFEs that are issued, the quality of adjudications improve.
I hope so. I'm ready to be out of this growing pains stage. I'm ready to be out of the US election, and the employee turnover, and to see all of these things return back to a little bit more of a normal pace. So I look forward to all of these things returning back to a more normal baseline. And I would think that the officers would too, and that the agency would too. RFEs are not cheap for the officers, or, they're not cheap for the agency, and the officers, it's more time for them too, right? Having to touch that file more than one time, having to write those RFEs, even though they've made that process a little more efficient, it's still time consuming. So I hope for everyone, everything starts to even out. Well, Roshn, thank you so much for your insights on the RFEs. We really appreciate you being here and talking about these trends and your leadership on that team. Such an important thing to do. And I just want to say thank you again.
Of course, thank you for having me. It was a pleasure.
Thank you.